We're going to be talking about testing obligations and what vendors of AI systems should be doing and what kind of terms we're requiring of them when it comes to testing models for bias and disparate impact, either before or during deployment. I have a AI slop drafted provision that I asked AI to just give me its best testing obligations provision. And we're going to look at that and talk about what it says, what it's missing, what it gets wrong. But first, Linsey, I want to ask you to set the stage, not from a vendor or customer perspective, but really thinking about AI bias testing obligations. And what should these provisions include? And what do you see contracts commonly miss in these kinds of provisions?
Yeah, this is an area where regulation exists in some senses. There is existing regulation that is technology agnostic around like employment, for instance. If you are selling into a highly regulated industry like employment or financial or health, there might be some regulations that even speak to what bias testing is, what we're even talking about, right? That would be instructive. And so flowing those into what your practices are and then what your contracts say is important. So we're not necessarily just making this up. But I think one of the things that is a backdrop to this, and I alluded to it earlier around the moving target of regulation, is we have the EU AI Act, for instance, that it is prescribing pretty specific testing requirements. And not only testing, if I could just take a step back just a little bit, but validation. So there's like this testing that happens during training of a model, for instance. So you need to look at your training data, make sure that's not biased. How do you do that? You test for it, right? And then you run it with real world data and you validate, right? And these two concepts can be conflated. So I think it's helpful to think about those two things as a bit separate in terms of the process on the back end. And I think just keeping in mind, how often do we do this? We've talked about drift and the zoo animals, right? And the weather. And how often are we testing? So, what's the frequency? What's the methodology? What are we using? If we've got an existing regulation, for instance, under employment, we've got the EEOC that has some direction. It's fairly well established in some ways. Think about, what are you testing for? What, not only the methodology, but do we even know let's think about what are the protected classes? What are the protected characteristics that we care about? And then what happens with that testing, right? Okay, you test, and then do you just put that report in a drawer? Do you have to tell somebody? What do you have to do? Do you have to fix something? The answer is probably obviously yes to many of these questions, but these are the things that we're grappling with. And I will say that many contracts that we're seeing right now from particularly startup AI vendors likely will not address testing at all. It will be silent. You won't even have a provision. So this is an example of where, like, it's great that you have this AI slop language that we'll look at, and you might want to even just look at, is it even in existence at all?
Yeah. It's crazy, this idea that they don't even address it. And so it's up to the customers to make sure that they can raise that and be aware of those issues. And I think one of the other things that I see people talk about is this cooperation as well, that trying to make sure that on top of the testing obligations and who and what, all those things you were talking about, and sharing results, is the other one is this idea of imposing cooperation, which traditionally as a tech transaction lawyer was always fuzzy. And I never really liked it because it was like, what does that even mean? We're going to cooperate. It feels hollow in a lot of contexts. But here, I think in the absence of these clear guardrails and clear paths, like cooperation's all we got. We've got to tie our life jackets together and we're going to swim across the channel with our zoo animals and figure out our way. Yeah, that's fantastic. So I'm going to go ahead and share our first provision that we can look at and kind of talk about together. And this is this idea of AI testing obligations. Let me just read it out loud just so we're all on the same page. Vendors shall conduct periodic testing of the AI system for bias and disparate impact in a manner consistent with industry standards and take commercially reasonable steps to address any material issues identified. Customer may request a summary of testing activities upon reasonable advance written notice. So that's the language that AI came up with as a representative of a good provision. Linsey, I'll come back to you again as the vendor. I always start with the vendor first. When you see this language, I'd love to hear what pops out about it that's wrong or that needs to get fixed from the vendor perspective.
So first of all, as I mentioned, you won't see these in vendor agreements. And so first of all, I might strike it, right?
Yeah.
The whole thing. I would just strike the whole thing. In order to have ultimate flexibility, I don't want to, from a vendor perspective, commit to anything that I don't have to. However, if I am trying to build trust with my customers, we're swimming across the ocean together, what can I do to get ahead of this? Periodic testing can mean anything. What does that mean? It's very subjective. There's not even an annual requirement. And so having some type of cadence and getting ahead of that to make it workable, probably even not from a calendar perspective necessarily, but from the change in the system. So maybe it's testing at the change of the model or the system, a new version, for instance, might trigger when this testing might happen, right? Industry standards, what does that mean, right? We're in an area of time of great flux here. Things are changing very quickly. This is missing and applicable law. For instance, you might want to put in consistent with applicable law. At least then you've got a standard. Industry standard could mean something really high that maybe the vendor is not necessarily quite ready to step up to, or it could mean something really low, right? Commercially reasonable steps. This doesn't say best efforts steps. So it does, from a vendor perspective, might be helpful to, there is some degree of flexibility that we've always had with what do we do with if there's material issue, right? And materiality is very subjective, of course, as well. And so trying to get ahead of what a customer might expect and give assurances to the customer that something will be done with this, with any issues that are found. I do want to take a pause here and just relate this to what this reminds me of a little bit is in a different area is security incidents and versus material or legal breach that requires notification under US state data breach notification. This is similar, I think, in some ways where we're going to continue to see a lot of negotiation. And I expect that there will be some regulations emerging to actually determine what this looks like. So I would just say watch this space from a regulatory perspective, because I do think things will come into more focus and it may look similar to that kind of difference between incidents and breach. And the reason why is because if there's issues, the vendors want to, again, have a workable operational plan to be able to fix things and deal with the testing results. And then, of course, the summary of testing activities upon reasonable advance notice, having the customer just say, what's reasonable, right? So the vendor getting ahead of that and saying, this is what we're going to do. We're going to provide you a summary and it'll be available publicly, right? Or in our trust center, if you have access to that sort of maybe even a walled area where there are these types of reports available.
Yeah, no, I think those are trying to build in flexibility, but in the end, that sometimes comes back to haunt even the vendors because it opens the gate up to interpretation and conflict at a time when, you know, having transparency or clarity can prevent disputes more than cause them. Awesome. Let's, Olga, I'll turn to you. You've got your customer hat on, and I'd love to hear what kinds of issues you have with this language and what kind of things you would change.
Yeah, I feel like I'm negotiating with a vendor who brings more issues than a customer would. Lindsay, thank you for that. I'd love to negotiate with you every day. Honestly, I agree with Lindsay a lot. The biggest concern is that it does sound much stronger than it actually is around what periodic means, what testing means, what material issues. I agree with all that. I am a little bit more pragmatic about it, whether I will pick up this fight, for example. And it actually will depend on a couple of things. One will depend on how whether I actually find that data important and how material it is to me and the size of the contract. That's probably my big cut will be whether I pick up this fight, because this could be an endless fight and the deal may never happen if I really truly pick it up. The second thing is today specifically, and Lindsay alluded to it a couple of times, and I really love your addition around applicable law. That's probably the only thing I would truly add today when the law is not clear. Because someone who has a benefit of practicing law for now, I count this in decades, I've negotiated contracts where there is clarity and there is little clarity. And what I've found with privacy security, which I think where this is kind of trending in the ballpark, is that what I hope for is usually lower than some governmental agencies will set up, specifically in California, specifically in Europe. So honestly, reasonable and standard may sound just amazing because I count on the protectionist regimes to actually do negotiation for me at this point in time. So that's actually practically speaking. I do think that applicable law is probably the most important addition you have to make because that will be really hard to whistle out if you actually got to pursue it. And maybe the other thing that really jumps out at me is that customers only get information if they ask for it. And honestly, if this is important to you, that's really backwards. And it doesn't necessarily have to be in the contract, but what needs to be happening here is understanding where those policies, governance leaves, taking a look at it, may or may not put it actually in the contract. But what really basically needs to be happening, if you're giving data that is of any importance to you, you need to have a relationship with that party so you understand and have your hand on the pulse to make sure you protect what's yours. And contract is one place to do it. Contract is not a place to build relationships. Contract is not a place to build deep trust. You need to take it offline, so to speak, and really know the people you're dealing with, know your customer, know your vendor type of experience, and understand the humans behind the contract and kind of understand how it all practically works. And so, anyway, today I would definitely add the law. I would definitely think about how it's operationalized if it's truly important to me. And I will probably actually leave with a slap, if, assuming it's there, because I would expect that laws would be pretty strict.
Yeah, and I love that as a way, especially for customers, to piggyback on, as you said, the regulators negotiating it for you. And it's always a harder one to argue against an independent obligation. You vendor, you should do all these things, and the vendors resist. But you just say, hey, you have to comply with applicable law. It's a lot harder to negotiate against. Certainly, people do anyway, but it's harder to reasonably push back on that. And it also offers that evolving standard to to reflect where things are going. The other thing that's come up, and Lindsay, you mentioned the cybersecurity, data security issue, is we've had a bunch of webinars on that lately. And one of the things they kept saying was get whatever they're doing, whatever the vendor has. So in this case, they're doing some periodic testing already, attach the testing methodology used today. Not that it has to be fixed forever, but it having some kind of this is where we are at today because they have to have it and they already have it. So why can't they just attach it even if it's just an informational exhibit? Ideally, it's no less than this. But I thought that was really sounded a lot better than just the reasonable testing parameters or industry standard testing, like use something. So great different points on this one.
Can I just add in one more thing just to underscore
Yeah.
that this provision is important Like disparate impact should be a signal to everyone to be thinking about these are areas where we are using AI in a use case that could result in discrimination, right? So we're not just talking about testing to make sure the system works. This is actually for some specific areas, like we've mentioned employment, financial, insurance is another one. There are these industry specific AI use cases where this might be something like Olga mentioned. You might really fight for this one in certain contracts. So just wanted to underscore on that one.
Yeah.
And maybe even I'll actually double click on this disparate impact. That's a very high bar. That means you might have had great intentions, did everything right, and still had a bad impact.
Yep.
And so that's actually, I was surprised you didn't push back on that, Linsey. That's a really hard bar. We use that language today in employment law where the policy reasons are so important. We want to make sure that every member of our community has an opportunity to be employed. That's when we use that language. That's a very high bar language. If we're going to use this in the contract, I would think long and hard about you, if I were a vendor, requiring me to be responsible on the impact side, because I can invest infinite amount of money, energy, and still get it wrong and be at fault. That is usually not a commercial language.
Yeah, because it's about how the customer uses it as well. This is the cooperation that we keep talking about. And yes, excellent point, Olga, that this is just such from a legal perspective, disparate impact is different. It's a very high standard than talking about bias.
Yeah. And the way you prove it, by the way, in employment is by doing statistical studies. Yes. So this is also a nightmare of litigation costs if you worried about that on both sides. So both sides may not want to have that. I actually think it's a really problematic language in contracts, commercial day-to-day contracts.
I love that. No, and I didn't pick up on that at all. And I think you raising that is just another reason why just we're all grasping at straws of what to put in these provisions because we're trying to keep up. We're trying to understand what's best practice when it's moving so fast. And bias and disparate impacts sound good, but if the meat behind it, the real meat or real meaning is, like you said, much higher bar than necessarily is appropriate for a lot of contracts. And so this language could end up, like Claude drafted this language in there. And it would, if you're relying on AI tools to pull this together without doing this hard thinking and analysis of your use case and whether you actually want disparate impact in there. It's such a great point. Thanks for raising that. I'm like, yeah, for sure.